Welcome on behalf of Strata Community Association New South Wales. I'm Chris Duggan, the President. With me today I have our longest serving Director and Principal at Bannerman's Lawyers, David Bannerman.
Thanks, Chris. Happy to be involved in this session. It's a hard topic with all these changes and all the technological difficulties we're facing.
Look, that's absolutely right, David. So at the outset, let me say that this particular podcast and webcast series is aimed at our Strata lot owners out there. So hopefully you're out there. We've received many questions in advance. If you do wish to put questions in during the course of the day, please use the Q&A tab down the bottom, and David and I will endeavour to get to them throughout the course of today's webinar. We do intend to go for 1 hour. One thing I can say is that this is a moving beast. Even as at 5 minutes ago, the government came out with further packages to assure businesses to continue to maintain people within employment. So that too has knock-on effects into the stratosphere. And one thing I can also say is we don't have all the answers. We're working with an imperfect environment here on a global scale, but what we are doing is we're working around the country with our counterparts for SCA in each state, and we're working across the globe with counterparts as well to bring together solutions for you. So we've just been on a call more recently with New Zealand. We spent some time with UK and the US overnight so that we can understand their learned experiences to try and bring you what we hope are some solutions to deal with some pretty challenging circumstances that have been thrust upon you. One thing I can say is thank you to all of you, because all the Strata owners out there are the ones who will provide the leadership and the guidance to some fairly vulnerable communities in their time of need. So that being said, let me get into the questions. I've got David here for the full hour. David, I'm going to kick off with the first question, and one that maybe you have a very intimate understanding of, and that is isolation. So do you want to update everyone about what isolating means in the context of a strata apartment? And is there a difference between self-isolating and when there's obviously a confirmed case of COVID-19 in a building?
Well, I've got a bit of experience with all of those, and I'll give you sort of the practical rundown. So about 2 weeks ago, level 8 of our building, we're on level 7, had a reported case of the virus. The building was shut down. The government sent in their cleaning team, and then 24 hours later issued a certificate of re-entry so that you could have the continued occupation in the building. We were lucky that we had everybody ready to move to a remote environment, and so we did for that 24 hours. My takeaway for owners corporations is that you want to be thinking about being ready for such an event yourselves in the event that some shutdown occurs to either the whole floor, the whole building, or just part of the building. Ours was a commercial building, 12 levels, and the whole building got shut down because there was limited lifts, and they were concerned about the contamination in the lifts, which were all shiny stainless steel. And that's probably the longest lasting surface for the virus. Can be reportedly up to 48 hours plus. And from what I understand from various strata insurance policies, in the event of a relocation due to the virus, some policies do cover that. And the cost of relocating and the relocation expenses accommodation. So that might be an insurable event if that were to happen to your building. But as far as planning goes, you need to be aware of that. So that's in relation to a reported incident at the building. Now, if you do get a reported incident at the building, there is no obligation to report it to a government agency. If a report comes in onto the scheme's records via an email to the strata manager, that is treated like any other record of the owners corporation. And if somebody wants to do an inspection of the records, usually that's done for pre-purchase reasons, then that would just be a record that's produced at that point in time. However, where you have a workplace and there's a report of an incident in a workplace, then you've got an obligation to report that to WorkSafe. Now, as far as strata schemes concerned, some years back they introduced the work health and safety legislation, and they made it a little bit more unclear about whether an owners corporation was a workplace. And they came out with some clarity but left some gaps. So if you're residential only, you're not a workplace. If you're a commercial, then that could be a workplace, but we think that there's some pretty sensible arguments to suggest why that's not a workplace, even if it's a commercial strata scheme insofar as the strata managing agent's concerned. Now, So that deals, and if you do have an event in the building, you'll need to get thorough, proper cleaning, and there's different levels of the cleaning to decontaminate, and various cleaning companies are offering that. So you just want to make sure that as part of your preparation that whatever cleaner that you would have engaged is ready and able to respond to that issue. So you can get the thing cleaned up immediately and dealt with straight away. Now, I'll come to the next subject, which is self-isolation. So I've done self-isolation. This is my 11th day now. So I came back from an awesome ski trip in Canada. And what was reported to me today was that somebody on our plane had the disease, the virus. And, you know, if you're sitting near particular seat numbers, that you need to be concerned and go and get yourself tested. Fortunately, they were at the other end of the plane, so I didn't have too much to worry about in that regard.
We lost you for a moment there, David, but that's okay. Let's continue. You were telling us about your story around obviously being on the plane.
Yeah. So when you get off the plane, they've changed the law since when I got back, but when people get off the plane now, they're quarantined, obviously, into a hotel paid for by the government. But before that, when you came back, that was only introduced, I think, mandatory yesterday. Before that, you had to put yourself in self-isolation. You were supposed to stay at home. You were allowed to be in contact with family members. You were supposed to wear a mask when in close proximity with family members, and you weren't supposed to go out of the building. So what some people have been doing who are living in strata buildings is that they're adhering to those requirements, but when it comes to disposal of waste, they're simply just placing the waste in the hallways. And then it's up to a diligent cleaning company to then go and remove that waste and deal with it on that basis. Now, SCA New South Wales is looking at preparing some materials to try and keep people in their strata buildings connected, because if you do have somebody in isolation and they're needing various supplies, then other people in the building may be able to put their hand up who know those people and deliver the supplies to them and do all sorts of things to assist those people. So SCA, that's what's been happening with the CAI model, which is an American model.
David,
SCA New South Wales.
Can I ask a question? We've got one through on the Q&A line here, and it's around the workplace. So we understand the challenges of defining whether a workplace applies to strata, but how about the building manager, the caretaker, or the cleaners who are on site? How are they deemed in terms of being defined as a workplace?
Well, I'm not sure what the answer is there for those people. All I know is that those people are currently locking themselves up and only accepting phone calls and emails. And as to whether or not they're doing any reporting to government agencies, I'm not aware, given that it's a sort of a different industry. But it's something I'll have a look at, because it would certainly be a different environment workplace-wise than for a strata management company who's working in a different office altogether and providing other types of support. That's a good question. I don't know the answer.
If I can give you two indications of overseas examples, so the UK and New Zealand, we've been in close contact, and building managers in particular, where they can lock down on site in isolation so that they can still do their job, but obviously they're discreetly away from any owner contact. So they're still there to deal with all of the increased sanitation, the increased demand, arguably the increased social issues that arise when you have a lot of people living on top of each other. And one thing that should be pointed out is the buildings weren't designed to have so many people living on top of each other for so long without any relief. So from a safety perspective, a security perspective, and particularly a health perspective, there is a need for those building managers to either be on site or to visit periodically to make sure that these buildings are still operating like they ought to and like they're built to do.
Yeah, look, there's going to be real challenges, not just with the physical amenity set up for the building, but also, speaking from being in isolation for 11 days, there'll be certain mental challenges that people have got to face as well. Inability to go outside, inability to communicate with people in the normal way. I treated myself as though I was in quarantine, because when I was away, another friend on on 2 trips, and in the first trip, a mate, he was in Aspen, which was a well-reported problem area, and then when he came back to Australia before us, he got hospitalised with breathing problems and had every symptom under the box, but he tested negative. And since then, everyone else who's been at the trip, it's about 5 or 6 others who have had their test done, have tested negative. So there's certainly measures that people should be taking, that the government's advocating about self-distancing, isolation, staying at home when required. My daughter's school recently had a father who got an Uber and picked it up from an Uber transfer, and he was contacted because they worked out all these different Uber deliveries and all these different Uber passengers in the period while he was infected. So they're certainly doing what they call this tracing thing, where they're trying to find out the root cause and the root source of the problem and trying to shut that down. So I think the government's actually doing a pretty good job there.
Yeah, look, David, can I expand a little bit more around isolation? Because a lot of the questions that have come in are around whether you can establish specific rules and guidelines that provide either conditions of access to the building or restrictions around the way a building may want to put in place, for example, testing measures for any visitors or guests to the site. So how do we step through whether that is A, legal, and what mechanisms would you need to put in place to enable those restrictions or the conditions to be put on place with regard to access to the common property?
Okay. Part of the problem with any legislation that's rushed through without consultation is that it doesn't actually specifically address everybody's concerns. And so the legislation that the government's rushed through doesn't really pick up on this nuance of public place versus common property. So a public place would be like a government library or a government swimming pool, local swimming pool where the public's free to enter on payment of a fee. Now, strata common property isn't necessarily a public place, but it's very clear from the intention of the law and the intention of the government that common gyms, common property pools and the like would meant to be captured in their rules about not for use. Now, our advice to the strata community is ignore that gap in the legislation, treat the building as though it does apply, the rule does apply. If you wanted to, you could put up a bylaw to restrict access, or you may have a bylaw in place about restricting access based on safety reasons. So owners corporations can create a bylaw, it's a special resolution, get it registered, and then that would cover the gap that the legislation left when they made the rules regarding public places, not equaling common property. So
that would only be a temporary bylaw, obviously in place for the period of time that COVID's around?
You could do it subject to certain levers. So lever one is that the bylaw is removed upon whatever notification from the government about the removal of the restriction from those sort of venues. Or two, until such time as the owners corporation decides that it's safe to resume occupation in those areas. I mean, you will note that the federal government has a different tact to the different state governments. And so you may have different, and the public schools and the private schools have a different tact about schooling and everything else like that since this has been happening. So there's certainly plenty of opinions and plenty of views out there. And it would be reasonable for the owners corporation to have a number of levers on which it could rely upon to switch off that limitation for the safety.
Yeah, there's a question around meetings, which I'm going to come to from one of the participants out there, because David's got a whole lot of information around how to facilitate meetings, because meetings can't be held in person, but they can certainly still be facilitated. I'll get you to step that through a sec, David.
Sure.
So we do have a lot of questions still just around the physical parts of the common property, David. So gyms, even if they're in light use, are still deemed to be closed from a safety perspective. So your recommendation, obviously, and your interpretation is, from a blanket perspective, they should all be closed down to make sure that there is no, obviously, spread and that we're doing our part to flatten the curve. Yeah,
and I think when you're explaining to people who are feeling a little bit aggrieved about it, if they do actually impose an isolation where everybody is supposed to stay at home and they're wanting to go down to the gym, I think, you know, people just need to understand that there's a lot of people who are suffering quite badly in this as a result of being locked down, out of work, worried about the illness and worried about their financial longevity, that when it comes to using those facilities, you've got to be sensible. And that'd be the rule of thumb to apply to that.
Look, David, and that extends a little bit further. A lot of the queries we've got about when you've got families and children in strata, how the children potentially use the common property. So, you know, all the normal things that used to apply, you know, kids playing on common property, unsupervised, I mean, that may well be a reality for some time in strata. Do you recommend that there is a reasonableness approach now applied to the way we interpret some of the more conventional strata bylaws?
Yeah, look, the law is a fluid thing in relation to how it applies. And presently, the new law made that bylaws can't be harsh, unjust, or oppressive. Now, so if you put up a bylaw to cover the gaps in the law, it can be read down if it's harsh, oppressive, or unjust. So that's what I'm saying. If you've got those, you want to have those levers in there to say that it'll be retracted in these sort of circumstances. And I think that would then address the issues of it being harsh, unjust, or oppressive. Now, so what you then have is another issue that you've raised, which is a very good one, which I haven't turned my mind to yet, is what about just common areas that aren't those ones that are listed by the government, where they say you can go into the backyard, that you can go to the parks, and you can do these sort of things. So it's going to come down to the interpretation of harsh, unjust, or oppressive as to whether or not that bylaw is of any force or effect.
That's right. And I think, David, we need to recognise that if we're truly looking at a long stint of hard lockdown, that life needs to go on. People still need to get outside and get fresh air. Children need to run around. How that's managed is going to require a delicate blend of, you know, obviously proper supervision, but a degree of sympathy to make sure that we can get through this as a community. I'm just going to keep going on this tenet here, please.
There was a good question here about what do you... from Elizabeth Michelle, what's your advice about the use of shared laundries?
Correct.
Well, that's not covered in the government's list of items as far as I recall, and it's what you'd have to consider an essential amenity, and care needs to be exercised when using that. Such care includes the self-distancing. The lift is an interesting one, for instance. So if you've got a small lift and it's only capable of holding one person within the 1.5 equivalent 4 metre squared type parameters, well then, in order to comply with the government's self-distancing requirements, they'd be anticipating that you would have the sense not to jump into a lift with somebody where you'd be in breach of those conditions. Now, some countries have imposed different requirements, and who knows what Australia will impose, and maybe it'll be different state to state. Some countries have said that only one adult out of the household is allowed to leave for 1 hour of the day for certain things, and they're allowed to do one trip to the pharmacy and one trip to the grocery. And that's the extent of the use of anyone from that building in relation to using the common property facilities or being outside the apartment. Now, I don't know that Australia is looking at those measures at this point in time. We'll wait and see how the testing goes and how the spread in the community goes as to what measures they impose.
That's right. I think it's probably worthwhile to turn your mind, though, to how you may manage the common property in some of those scenarios. So still, David, sticking to some of the questions we've got here around access, how about what sort of rights do you have to refuse access to a tradesperson, for example? And what we've seen is tenants and residents refusing access for fire inspections, refusing access for compliance inspections. What sort of statutory rights and legal rights do both the tenants have and also the owners' corporation to continue their business as usual compliance obligations?
Okay, so that's a very good question as well. So the owners' corporations need to undertake all sorts of inspections and works in the strata scheme to comply with their obligations to make the building safe and to maintain the building. And that'll often require access to a unit. And the law recognises that the owners' corporation has a right to access the unit A without consent where there's an emergency. Now, could it be construed that a virus event is an emergency or they need to get access to the unit to clean it, to check the air conditioning systems, to do whatever it is to ensure the ongoing safety of the building? You'd have to think that that's the government. If the government became aware of it, they would certainly be exercising their powers of entry to go and check things out, and you'd be wanting to rely on those as before you went and relied on your own. But if you had to rely on your own, then arguably you could argue that it's an emergency. I think that's arguable. It's going to depend on the circumstances and what's going on. The second one, though, is that when it's not an emergency, and when it's not an emergency, there's a general right of access to the Owners Corporation to conduct repairs and maintenance to the common property, and the person is required to provide access, and the Owners Corporation's liable to for any damages that they cause to the people's property while they're accessing and doing repairs. Now, if an individual does not give access to the apartment, and the Owners Corporation then can apply straight to NCAT for an order for access. Now, these individuals may refuse access for all sorts of reasons. So quite often we're seeing that individuals are concerned that the contractor coming into their apartment is not safe and may have the virus, and that they don't wish to have that person inside their apartment. Now, that's certainly happening at a large scale. We're seeing it on two fronts. One is that occupants are refusing access, and two is that people who are contracted to perform those inspections are refusing to perform those inspections until they receive certain cleaning protocols and information about the safety of the building to satisfy the safety of their workers. Now, coming back to an individual owner, if they refuse to give access for the purposes of doing an annual inspection for the fire safety statement for the building, well then the strata manager can simply write to the council and say that we've been able to get access to this lot. This is the reason why I haven't been able to provide you with a complete annual fire safety statement. You are not entitled to issue any penalty infringement notices to us because we've got a specific defence in the legislation. This is the trigger for that defence. So we've done what we can. We don't have to go to NCAT to get an order for access. Now, this leads us into a second dilemma. So if the Owners Corporation did want to actually get an order for access, NCAT is, and like the courts, are all freaking out about in-person hearings. And because they're worried about the transmission of the virus themselves. There's already been instances at the federal court. And so it's a watch this space at the moment at NCAT, which is the place where you would go to get an order for access in the event that somebody refused to give access. Now, NCAT at the moment, as of Friday, they issued a urgent amendment to their practice note to say that if you want to lodge documents or applications, don't come and see us. You can lodge it via email with the credit card number and give us a phone number so we'll call you to use the credit card online. But you can only lodge it online though if you can't get it lodged through Services New South Wales or the Post. Now, a lot of businesses who would be lodging those applications have told their clients to stay at home and not go and visit certain government offices and things like that. So they might be trying to simply lodge their documents online. NCAT has a different hearing process now. They're conducting hearings by telephone as opposed to in-person hearings. But they've realised that there's a limitation on the way in which they can do those hearings, because if you've got an expert who's got to be cross-examined and you're trying to show the expert, and you formed this opinion based on this document, and can I just point you to this part of the document here? Can you please elaborate on your reasoning because it doesn't match the conclusion that you've drawn? And so what that means is that the tribunal is now looking at not hearing cases for 6 months where an expert would be cross-examined on materials. And that means that they should still be able to run with an access application if they've got to get a special order for access because someone's being unreleasable in relation to that access application. But it may be that they change their attitude about even those type of applications. So they're allowing hearings where there is no cross-examination of experts to run at the moment. So we're running a hearing I think it's just concluded. It was supposed to be finished at about 11 o'clock. But they're having such difficulties down there running hearings with their technology at the moment that they're just struggling, and all the hearings are taking way longer than anyone could have ever thought. But they are still running hearings.
So, David, you just mentioned the courts as well, and the courts are clearly the vehicle for lawyers like yourselves lodging claims and applications for statutory warranties, for major claims. How do they work? Because as far as we know, the Home Building Act still applies, statutory warranty timeframes still exist. What's your advice for how we navigate that more complex issue?
Another great question. The government released recently a statement of intent it wasn't really much of a statement of anything except to say that relevant to this industry, it's the state of plays as normal. The strata managers have got to meet their licensing requirements. Everybody's got to meet their statute of limitation issues for their defect claims. So there's been no reform from the government to provide extra time for doing things in the event that they were required to be done. So it's business as usual there. Now the courts do have some solutions though. Like the local court has a lot of online lodgement. They're looking at delaying in-person hearings. The Supreme Court is using Zoom for different types of hearings and written submissions for other hearings. So the courts are scrambling and cobbling together solutions quite quickly, and it's an evolving situation at the moment. But as the government has said, everybody's got their same obligations, so no one's getting any leeway when it comes to, preserving rights or claiming debts, except to say that people will have more time before a hearing is likely to unfold in a lot of matters.
So one thing, David, that we've seen particularly overseas is this argument about what is an essential and what's a non-essential service. So the two material factors here are obviously what level of materiality is there for essential management of a building, i.e. on-site management, and we referred to before to cleaners and caretakers. And for all of our participants' perspective, New Zealand has a real challenge here because they've deemed that conventional cleaners are not an essential service. So they're dealing with, it's absurd. And we're dealing with obviously increased and immensely increased demand for cleaning and sanitation of the common property.
Yes, super dangerous.
So that's problematic. But the UK has a different perspective. They deem it that a plumber who is attending an emergency event is a essential service, yet a preventative sort of maintenance regime is not. Is there any legal context for the way we should interpret this, or is this a bit of a suck and see type thing?
Presently, the only guidance to what's essential is, and it seems to be different, but from the federal level, it's anybody who's got a job's considered essential because all the people who have been laid off, they're sort of construing those as non-essential. But then what I haven't worked out the answer to is that for schools, they've changed the rules for attendance to schools to public schools. So they're saying that if you're essential, then you can have your kids at school. I don't know if the state government's using the same definition of essential that the federal government's using for when it's considering essential for allowing people to attend school. But as far as the Strata Committee is concerned, at present, unless you're one of those businesses which have been identified to cease operating, you are considered essential to the economy.
Yeah, can I just expand on that, David? As an SCA level, we're in very deep conversation with government, and we're actively advocating to make sure that the ecosystem of strata is not just deemed essential but critical, because making sure that we have viable and operational strata schemes and communities across New South Wales as we go into these unprecedented times is going to be essential. There's not just the safety and security, there's the sanity and those human elements. So I want to touch a little bit on that, David, because we talked about those mental issues, the mental health issues. We talked about the challenges and compliance. So how do we deal with increased behavioural issues in strata where you've got residents living on top of each other for an undefined period, with, you would imagine, more noise, more waste, more, certainly not a lot of parking issues because people hopefully are going to be staying home, but a lot of enhanced sort of issues around the human behaviour. How do we expect and how do you propose to handle those things based on particularly your own experience of being isolated now for a couple of weeks?
Yeah, I can say that the noise will be an increasing dispute issue. People who are trying to effectively work from home in their remote environment will need peace and quiet, whether it's for a Zoom call like this one, or whether it's for just affecting other types of calls and things like that. And so you would hope that the community does adhere to the sensible noise issues. But if you've got I'll tell you what I'm finding right at the moment is I've got 3 kids effectively working at home, and they're Zooming in to school and doing e-learning, and they're all flat out. And so you'll find that there'll be peace and quiet during the school days, but we're just about to go into school holidays in less than a couple of weeks, and these kids won't have the structure that stands around attending classes by Zoom and doing all of those sort of things. And I think that is then going to create a whole lot of issues. Now, presently, the only legal avenues that are available is that, you know, if you've got bylaws there about noise, you've got bylaws there about floor coverings, you've got an overriding legal principle about not creating a nuisance. So I can see that in reality, what's going to happen is people are going to be calling up the strata manager saying, this is getting unbearable, I need the committee to resolve, to issue a notice to this person, so they pull their head in, because it's not just affecting me, it's affecting the business, it's doing all these sort of things. So I can see an acceleration in the issue of notices to comply in response to that. And then if people respond to those notices to comply, or if they don't comply, well, then there's still the option to go and take a matter to NCAT and file an application in NCAT for a penalty dispute. I can certainly see a significant influx in those applications being made in the event that people are required to isolate, because regrettably, the noise transmission between units, some is better than others, and in quite a few, the noise transmission is not adequate for people to be fully occupied and to be seeking to have peace and quiet enjoyment to effectively work properly.
No, look, I think there has to be a healthy dose of patience through this as well, as we all try and navigate the new challenge that will be strata living under isolation. Now, I'm going to turn to some economic questions now, David, and some of the questions that come through on the chat I know have been posed to many strata agents, and that is, what's happening around unpaid contributions, particularly around interest, and as the economy continues to turn, what's the longer term implications? And just before you do get to it, David, at an SCA level, we have lobbied the government for a number of measures to intervene and actually provide immediate relief. One of them is that we'd like to see interest stopped immediately in a mandatory fashion across all strata plans until such time as everyone can get their head above water, and offer more innovative solutions for owners' corporations to consider deferring capital works fund plans if necessary, transferring funds between capital works and admin funds. But all of these are options on the table. I would also say that SCA is preparing a set of standard bylaws, so not bylaws, rather motions to be considered at general meetings that we'd like to pass out to our members to consider a raft of cash flow initiatives, because strata plans do still need to pay all the suppliers that go with it. They still need to be insured. They still need to pay the electricity and the utilities and other things. So the economy of strata needs to move on, but it needs to be sympathetic to the fact that we've got a lot of very vulnerable owners who are impacted in significant economic ways. So turning to legal remedies, David, at the moment, we don't have a lot of wriggle room, as you said, with the statement of legislative intent the government put out. So how do we navigate that, and what options are available to owners?
Okay, so the initiative that SCA is doing, I've had a quick review of some of the documents. I haven't had a chance to finally review it all. But just people, you're exactly right. Owners corporations need to continue to be safe and to be maintained, and that requires the use of third parties and the payment of fees for such. What I can see happening is that people will review their capital works fund plan and amend it, and then rescind motions where they are trying to raise levies to cover certain expenditure that they're going to put on hold for a longer period of time, and that effectively reduce the contribution amounts to the capital works fund, and therefore ease some of the pressure that's placed upon the owners in relation to financial contributions. I saw an email yesterday from somebody in relation to a debt recovery matter, and they said, oh, there's no need to pay any levies for 6 months. And that's just completely not true. What has changed is that if an owners corporation got a judgment debt against somebody, and they served a bankruptcy notice or a winding up notice, that there's effectively a 6 month notice period for that person to comply with. And what's happened at the local court is that the local court, like the other forums for disputes, has been concerned about contamination with the virus, and they've said that they're going to stop running hearings for quite a while, and I don't know when they're going to get it back up and running. So owners corporations may be able to progress their levy recovery to an extent, but to the extent it became a defended hearing, well then there's going to be a problem getting the hearing, because the local court needs to have adequate measures in place to deal with audio-visual problems which they're still developing. Now, with a reduction in the capital works fund, owners corporations may also wish to consider a reduction in their administrative fund, but care will need to be given there, because there's going to be more strain on the administrative services required for the building. There's going to be more cleaning. There's going to be more management fees. The building manager is going to be doing more. The strata manager is going to be doing more. So I would be suggesting that there will be not much of a reduction in admin costs. One could expect an increase in administration costs just with all the extra things that have got to go on at the building these days to deal with these problems, and which is significant when there's problems at the building.
I think just to that point, David, and it's come through here in terms of some of the Q&As, is regrettably, we still haven't worked through some of the major issues that were sort of maligning our industry around defects and cladding. And there's a very valid point that cladding's, it's been pushed under the rug. And one of the points that we've been making and have been lobbying for is we've asked the government for substantial funds, upwards of $1 billion to support affected strata residents in clad buildings sometime last year. Now, I won't say that's been forgotten, but it's certainly funding is at the moment. And the real issue we have is that we're now asking people to cohabitate in greater numbers than ever with these issues still there and unresolved. So we're continuing to take this fight to government. We're making sure that they're aware and sympathetic to the needs of strata owners and residents across New South Wales. But you can see as we unpack another issue, something else comes up that creates a whole level of complexity. And I would also say, David, that, as I said, 10 minutes before going into this webinar, the government released even more information around funding packages, which hopefully will support people who find themselves either out of work or significantly impacted, so they can support some of their outgoings on the way through. But the challenges are significant.
Yeah, and because of more people living in these buildings and not being able to leave, there's no let up by the councils or the fire brigade in relation to the removal of the cladding that we've seen to date. In fact, they're still issuing notices and orders for people to remove the cladding, despite the difficulties that these people would face in actually getting contractors on site and all these sort of things. So the government is going, what's happening in it's a bit of a full cycle thing. So I'm going to explain what's happening on the construction sites at the moment, is that in order for people to maintain self-distancing, some people are unable to effect their work properly because they need to work in a close proximity. It might be 2 people required in a small room to give effect to the installation of something because one thing's really heavy and you need to have another person support it while another person, attaches it or props it up or whatever. And so to the extent that certain things come to a grinding halt, the construction industry is all wondering about, well, what happens to this contract? If I can't do the contract, does that mean I still get paid for what I did? Or does it mean that I can just stop the work? And so they're all scratching their heads about what this means. Like, for instance, although China's heralding a great return for their economy, in certain parts of China, like I've been speaking to people who know people in Wuhan, and they've said, although these construction companies have 800 people, they're only allowing 10% to return to site. So 80 people out of 100 doesn't equate to getting much work done, except for turning a few pages and doing a bit of paperwork and maybe a bit of site organisation and cleaning. So although the Chinese economy is suggesting that it's back to business as usual, it's not back to business as usual there. And so the reason I'm explaining that to you is that if that's what happened there under a non-democratic government, where they could turn these things on and off a lot better than what a democratic government could do, then what will be the flow and effect for owners corporations who are trying to comply with an order to have cladding removed? Surely the government's got to see that, they've got to change their approach to the way in which this is being addressed.
Yeah, and look, and that's a constant dialogue, David, that we're having. I fear, though, that the government is dealing with, too many fires on too many fronts at the moment. But rest assured, we're going to continue to make sure it remains front and centre. And we're working with the government and have a business case before them for funding around an education campaign to support owners in strata, because we recognise that this is not a problem for today. This hopefully, well, not hopefully, but this looks like it's likely going to be a tomorrow issue that we need to solve, particularly if we go into firmer and harder lockdown.
And to that end, there are numerous options that are available to owners corporation in relation to obtaining finance should they walk into difficulty with pretty lengthy payback periods and things like that. So if the Owners Corporation was faced with significant work that they had to do because it was unsafe or because it was causing damage to other parts of the building, but they couldn't fund it through levies, then certainly there's a number of finance options that are available there, although owners may not wish to take up that option. They may prefer to defer it and cop the consequences, or they may prefer to just deal with it on a levy basis.
That's right. I think cash flow management will be critical, and I encourage all of you out there to work with your strata committees, your strata manager, and all of your other engaged, building management team to make sure that you understand your cash flow in the short term, can work to smooth it as much as possible. Obviously, allocate funds as required to keep your building operating, to the best of its performance that you can, but make sure that you do recognise that you need to be sympathetic to understanding owners' particular predicaments. David, meetings. Now we've got about 10 more minutes to go.
Okay.
For 15 minutes. Let's talk about meetings, because there are lots of challenges that have been thrown up around facilitating meetings. I would say that New South Wales, of all the states in Australia, is the only one that has electronic and other forms of meeting enshrined in its legislation. Talk us through the options available to owners who now can no longer have in-person meetings.
Okay. So the strata community in New South Wales isn't just strata title. So I'll just tick the box about some other varieties of strata living. There's a thing called community title, which is, like your breakfast points in your horizontal subdivisions. Unfortunately, they don't have the electronic meeting processes that are readily available to the strata community as of a couple of years ago. The government was looking at putting in legislation effective from November, which would have given those rights, but I don't know what they're proposing in relation to introducing new reform for that. That might get pushed out again. Now, fortunately though, for those community associations, is that you could simply set up a Zoom meeting, give everybody everybody give the strata managing agent a proxy, and then they can have the meeting on Zoom. And then when the manager comes to count the votes, he can just say, all right, Bob, how would you like to vote? And he just notes down everybody individually as per their wishes. So he can receive their wishes via the Zoom instructions. The meetings will take a bit longer. Otherwise, on the proxy form, and the managing agent could have all the proxy forms for these ones, is that they could specify yes or no to vote 1, yes or no to vote 2, etc., and give specific paper instructions as opposed to online instructions. Now, and that's totally legitimate. You've got more of a problem though with a rarer beast, which is the company title buildings, where you'll have to look at your articles of association as to whether or not they will permit that sort of meeting. And usually they're old documents drafted in the 60s, and unless they've been recently revamped, they won't deal with electronic meeting processes. So they'll need to conduct a meeting in the usual fashion, or otherwise amend their articles and then conduct a meeting in the usual fashion. But to amend their articles, they'd have to conduct a meeting in the usual fashion. They'd have to check to see whether or not that usual fashion permits proxies and things like that under the terms of the Constitution. But that leaves us now with the majority of our constituents in the strata community, which is those that are created under the Strata Schemes Management Act. And there's all different types of decisions that are made. So we'll start with the managing agent. Under their agreement, they have a delegated authority to do things without consulting with the owners, and that's called a delegated authority. And it's a limited delegation, and they can exercise those decisions without input from the Owners Corporation, but they're limited. So one thing that they're limited to is to making bylaws or raising levies, for instance, so things which are required to be determined at the general meeting. Now, to the extent that you need to get a general meeting, the next level is the Strata Committee, okay? And so with our Strata Committees, they can have postal votes. If they've had an earlier determination at a meeting, it doesn't need to be in the form of a bylaw, but if they've decided, and this is, most strata management companies did roll these decisions out some years ago, and they don't have to do it every year. If there's a decision that they made a couple of years ago, well, then that's legit. They can just rely on that decision. And those decisions will often refer to, we were involved in drafting a lot of blanket precedents for this, electronic pre-meeting voting for strata committees, or attendance via Skype, or whatever is some online platform that the Strata Management Company is currently using in conjunction with their database and system, then they can conduct Strata Committee meetings in that fashion. Now, the general meeting though, now the Strata Committee can't raise levies. The Strata Committee can decide to back off on interest payments. They don't need a general meeting for that. But they can't determine a levy, or they can't waive a levy, and they can't make a bylaw. And so what the Strata Committee, the general meeting can do is, if you've got, and this is a little bit complicated here, so we've got two types of general meetings. We'll call it annual general meetings where there's an election of the committee, and we'll talk about extraordinary general meetings. So if we've just got an extraordinary general meeting, you can do that solely by in-person voting. So, or you can do it solely by electronic pre-meeting voting, or you can do it with a combination of both. Again, though, you would want to have a decision either at a committee level or at a general meeting level prior to conducting the meeting in the fashion that you can conduct it in that fashion. And like I said, most owners corporations with professional managers have had a decision in recent years which they could turn back to rely upon to conduct the meeting in that fashion. Now, at an extraordinary general meeting, you can modify levies or you can make bylaws. And what you could do is you could, in fact, if you wanted to, you can do online voting if you liked as well, if there was such a decision. If you wanted, in strata schemes, there's a 5% proxy limit, but that's to an individual. So Strata Management Company might elect that we'll name 4 or 5 different individuals from our business to cover the 5% holdings, and we'll conduct a meeting and they can hold the proxies. And you know, you can do what I said before about the Skype thing if you wanted to and get instructions via Skype, or you can just take it written on the form. So what I'm trying to explain is that at EGM, it's pretty straightforward in relation to having non-attendance at meetings. So we've told our strata managers that in order to facilitate the government's intentions with the legislation is that they should warn their clients when they're issuing the notice for the meeting that they're only going to hold it in electronic format. And if somebody feels deprived of the right to vote in that electronic way, then they have a right to go to NCAT and say, well, if they were deprived of the right to vote and it would have changed the outcome of the meeting, well, then that motion will be overturned. Now, if the strata managing agents communicate well with their clients and all their clients are on emails, which is going to need to be the case now, things need to move quicker than ever now with certain decisions and certain notifications. And if you've got clients, if you're an owner and you haven't given consent to your strata managing agent to communicate with you via email, the first thing you want to do following this is to write that email to your strata managing agent and say, we consent to receipt of all notices and communications from the Owners Corporation via email. That doesn't have to be signed. Your email signature is adequate in order for them to change that communication point on the strata roll, and then you'll be communicated going forwards via email. Now, I'm going to move now to the annual general meeting because this presents a small difficulty in relation to the election of the committee. Now, the committee election, it says that you cannot use the electronic meeting process for pre-meeting electronic voting, that is, for committee elections. So you can still do the online voting election. You can still allocate proxies to different people to cast in the management company to cast the votes. But if it just works out that there's just, it's all electronic pre-meeting voting and the committee's not elected because there wasn't any votes that could have been counted, well, then that committee just rolls over to the next appointment and they just keep going until there's another election of the committee. So it's not the end of the world, contrary to what a lot of people think. And so the committee just stays in play for another longer period of time. So I hope that answers the question. I know it was a bit of a long answer.
I pitched it up to you, David, knowing full well that it was going to be a long-winded answer, and I thought it was going to cover off on a lot of the sort of procedural matters. One thing I could say is that if you have questions around the method or manner or options available to you to hold online meetings or meetings other than those in person, please consult with your strata manager who will give you those options. And there are ways around this. And as David said, this will lead to innovation. It will also lead people away from on-site meetings where, as an industry, we've been trying to move at least to other forms of meeting attendance. And hopefully now we'll see a lot more participation in the democratic process continue, but continue in other forms of obviously attendance where people can come in however they want. So I've got 3 more questions here, David, that I'm going to round out with you if you don't mind. The first one is just going back to the advice we had around the mindfulness of cash flow management and financial hardship for owners. What are the legal and insurance implications for owners' corporations that elect to defer necessary repairs?
The government has made it clear that they're not letting up on obligations for safety and maintenance. And so if an owners' corporation elects to defer a fix to a building and that fix is causing a loss to somebody else, well, the owners' corporation is liable for that loss. And our firm has been involved in probably a dozen cases where people are claiming loss of rent because of the failure to fix the building. And loss of rent seems to be the number one loss. Apart from bundled in with that is like damage to carpet, damage to furniture and fixtures. We've also seen some significant personal injury claims arising from that as well, being mould related, where people are saying we've been poisoned by the mould and it's affected me in this way and I'm going to want a massive payout as a result of it. So there are quite a number of damages cases and a lot of them settle and a lot of them don't. And you're best to avoid those. So if you've got a repair that's causing a loss to somebody else, our advice is get on and address that as a priority to avoid the dispute that's likely to follow together with a claim for damages and losses.
That's right. So the law's not going to stop for anyone, although we're trying to weave solutions around it, David. We still need to get on with as business as usual as we can.
Yeah.
Now, second last question, David. Does the committee have a duty of care to other owners to tell them if there is a confirmed case on site without naming names? Now, for those who are out there
good question. It's absolutely.
David, before you jump into it, Dave, before
Sure.
you jump into it, we covered this in an earlier webinar, which is available on the SCA website that you can get into because there are also privacy considerations. We had a privacy lawyer on at the very early onset of how to deal with this. But sorry, I cut across your answer, David. Talk through it.
Yeah, as I mentioned right at the outset about if there's a reported case at the building about what the mandatory requirements are for disclosure, i.e. if it's a workplace to work cover. Another potential one, but not for an owners corporation, but if you've got a high-risk building and it's got lots of problems in it, they passed some new laws about disclosures of adverse affectations that landlords should give to a tenant. And if the building is riddled and has ongoing problems with the virus because numerous of the occupants are infected and it just keeps on more and more cases popping up through the building, well, then that's a safety concern that the landlord should be notifying the prospective tenant about before they sign the lease. And that also extends to the agent if they're aware of those issues as well. But as far as a committee member's requirement to notify a government agency about an outbreak, there is no such requirement unless they're operating a business that's in their workplace.
All right, last question, David, before I wrap up is if we've got a noise issue that comes because someone is using residential premises for a business purpose, does this have an impact on the legitimacy of a noise abatement notice?
What you'll find is that there's this other act called the Protection of the Environment Operations Act, which provides special council powers to investigate and cease commercial activities which are causing a noise interference to people in the building. So often we've been engaged where, say, there's a fitness first and you have people dropping the heavy barbell with the weights and you have this thundering vibration through the strata scheme, as an example. And you might have, alternatively, a very noisy air conditioning unit from a commercial unit, which is, using selling food or now doing takeaway. And then you can rely on these council powers beyond the bylaws, where the council can go do an inspection, do a noise test, and then they'll issue a notice to those people to cease and desist that type of activity until they can do it without interfering with the use and enjoyment by the neighbours.
No, thank you, David. There's always a way. And finally, there's one question just sort of following on from your meetings. If they don't already have a meeting bylaw or a bylaw allowing electronic voting, how can they facilitate that? So you stepped through some of those options. So give us the short.
Sorry. So what I'm saying is, look, you do not need a bylaw to do electronic meeting. You just need to have a committee decision. Now, a committee decision can be done by postal vote, so let me clarify this for you a little bit further, because we get this question a fair bit. You do not need a general meeting resolution to give the general meeting power to do electronic meeting processes. The Strata Committee can give the general meeting power to do meeting with electronic meeting processes. The Strata Committee can also give themselves power to do electronic meeting processes. If the Strata Committee doesn't have the power yet to do electronic meeting processes because perhaps they didn't have a Strata manager or the Strata manager wasn't up to date, whatever, the Strata Committee can do a postal vote. And then they can vote by following the postal vote mechanisms. And then in that postal vote mechanism, so they don't meet in person, it's a postage thing, and then they can decide at that Strata Committee meeting that they can do the general meeting in the electronic meeting format, and the Strata Committee meetings going forward in the electronic meeting format that they desire to do it in, whether it's Skype, Zoom, or whatever.